Hello. We get anybody else registered?
All right, everybody, thank you for joining us tonight. We're doing what we call estate planning for parents of children with special needs. This is brought to you through the Crossroads Continuum. I'm going to introduce us in a quick second, but this is a conversation, and really, this is a conversation that we have with all parents. In fact, we have this conversation, Craig, with just about everybody, right? It's not just parents of children who are differently abled or have a disability. Like, this is not only just parents, it's everybody who needs to go through some of these legal documents and understanding exactly what they're doing.
Right, at some level they touch everyone. That's correct.
So a little bit about us real quick. My name is Tom Alessi. I'm an investment advisor, now a certified fiduciary. I've been in financial services for 25 years. As a fiduciary, I am, guided to give the best investment advice I can, held to best interest rules for my client whenever I'm giving guidance or advice to any of my clients. My co-presenter this evening, Craig, can you introduce yourself?
Sure. So I'm Craig Richardson. I'm a financial services representative. I've been doing this for a little over 20 years now. And I specialize in working with families and individuals to help them define their financial goals and have a better relationship with their money.
And Craig will be joining me as we go along with this. And again, if you have questions, feel free to drop them into the chat box as we go along. Craig will be manning the chat box to get those questions answered. Real quick on who we are, the Moody Street Group. We're a financial services firm. We're located in Newton, Mass. We dedicate a portion of our firm to what we call the Special Needs Resource Network. The mission behind the Resource Network is just trying to be at that resource, that piece for a family who's dealing or working with a child who's differently abled or has a disability. One of the goals of the Special Needs Resource Network is trying to connect with as many organizations like Crossroads Continuum, advocates and other professionals that we can, so we can try to be that resource. We know only so much, and we connect to people across the spectrum of the special needs community so that we can help and address and reach out, Craig, whenever necessary.
Absolutely. There's so much out there in the special needs world to know, and there's so few people who know it all. So let's try to
Right. And try to connect with as many people. All right, so instead of an agenda, when we talk about estate planning, it's more about considerations, things that everyone should be thinking about when it comes to looking at your estate plan. And the first one is very simple, like, who's going to get my stuff? Where is my stuff going to go? Who's going to inherit these assets? And we'll talk about that. We do this whole thing on trust planning and able accounts and means tested government benefits. But when we have a child who will become an adult who will qualify and is entitled to these benefits, who's going to inherit those assets becomes one of those drivers, Craig, right?
Yeah, because everybody's got stuff, right?
Everybody has stuff, yes, right? And who's going to be responsible not only for once you pass, but what happens if you become incapacitated? What happens if you're no longer capable of handling your stuff? Who's going to deal with that?
Mhm.
Is there going to be taxes that are going to be due? We know where taxes happen and everything, what is that, the old adage, death and taxes, right?
Death and taxes for certain, right?
Yeah, everybody's got to deal with it, so how do I think about that? How do I pass that? And it's not only for the case of dealing with parents, of a child that's going to grow to an adult who might be qualified for benefits, right? Not just a tax efficient way, but how can I do this in such a way where I'm not complicating their life or their future by doing that?
Mhm.
What structure is the best? And again, with the challenges of what happens, because I'm planning for my child, I've got to plan their lifetime out, and then how does that come into effect with my stuff? you know, a lot of times, Craig, when we deal with parents, the conversation is, whatever's left at the end of the line, right? You know, I'm gonna leave the house or the retirement account or something, whatever's left over once I pass, that's what's gonna go to the child.
Yeah, we call those remainder assets, whatever remains.
There we go. Whatever remains. And what happens if I run into a situation where I start or drain all of those remainder assets? Then what? And so these are the considerations, these are the things that come up. Now, yes, not everybody has to go through every single one of these, but everybody has to deal with some part of it. It's just harder and more involved when we're dealing with a child who might need care or might need ways to have funding future than just, hey, I'm raising an adult type of thing.
Absolutely.
So what happens if you don't have a plan, right? And we're going to go through each of these and talk a little bit about it. But, you know, the idea here is that, you know, basically the state that you live in, they determine where your assets go. You don't have any control of that, no matter what happens. All of the penalties that could get assessed, you know, whether that's from tax standpoint or probate or anything like that, they get lumped in. And you really don't have any additional control, because see, some of the levers that we can pull, Craig, are levers that we can pull from beyond the grave, because we can determine who's going to get my money later on after I'm gone.
That's kind of spooky.
Yeah, it is a little spooky, but it does help sometimes, especially from a tax standpoint, especially if we're concerned about maybe, you know, we get this a lot every now and then. We have one child that's a little bit, let's say, not as responsible as maybe his siblings are, and they don't want the money to go to that one child. They'd rather have it get, you know, among the children who are going to do well with it versus not.
I like how you have the law determines where you put. I thought it was Judge Dredd.
Yeah.
I'm the law.
Judge law, right? How assets are transferred or inherited, right? So, you know, and we're going to talk about a will and what goes on with a will. But, you know, a will is there to determine where your stuff is going to go. And like we said, if you don't have a will, then state law steps in and it's going to control it. And then the other is beneficiary designations. And this is another one that trips up a lot of families, because there are a lot of assets that are held that have beneficiary designation. The first one for most people is their retirement account. I've got a retirement account at wherever I work, and I named a beneficiary. The problem is maybe that beneficiary is still alive, maybe they're not. Maybe they're still in the picture, maybe they're not in the picture. But it's something that needs to happen on an ongoing basis, to be thinking about those. And we'll talk about beneficiary designations and why they're so important and why they're meaningful and need to be addressed on a regular basis. And then lastly, if you have stuff that's joint ownership, right? So that's you know, husband and wife, usually, okay, we both own the home, you know, that's how that gets transferred if one of us is not alive. And then we have a trust. Right? And a trust is a way that we control where this stuff goes. So in looking at these estate documents, Craig, when we line them all up,
Yep.
looks like this. And we're going to go through each one of these. But in the case of, if you sit down with an attorney in today's world, what they're going to do with you is they're going to put together a will, a power of attorney, and a healthcare proxy, depending on where you live. We're in Massachusetts, it's healthcare proxy. We'll talk about that when we get to that particular thing. Living will is an opposite to that. They won't talk about HIPAA, and they may be a trust, but that's something that's an add-on. But we're talking basic legal documents. This is where we talk about what everybody should have. And by everybody, we mean anybody. If you're married, you need a will. If you've got stuff, you need a will. Everybody. All right, so a will, it just basically, it controls, right, Craig, where you want your stuff to go.
Well, yes and no. What it does is it determines your wishes on where you want your stuff to go.
All right.
Will still go through probate, so the court still has to decide that no one else has a claim on it. So you could say, I want all my assets to go to my children, but you've got a creditor who still is owed money. So that, right? So a will goes through probate, and when a will goes through probate, all the assets that you have are listed for public consumption, so they know and see what the assets are, so they make sure that nobody else has a claim on it. And then if there is no claim on it, then typically the will's instructions are followed.
Right. Right, and the other one that's on there is it's designating a guardian for minor children. So this is one that comes up every now and then, Craig, like we talk to parents and they're, and they've got young kids and it's like, no, we don't have a will. I'm like, you understand that then the state family court is going to choose who's going to be raising your kid.
Absolutely. And if nobody steps forward, they could become wards of the state and end up in foster care.
Right.
Yeah.
Right. And that's sort of the, hey, what happens without a will, right? So the state is going to decide who gets your assets. And the reason we bring this into the conversation is because this is where we start getting into about, all right, my child who is going to grow to an adult, or maybe they've already become an adult, and they're differently abled and they're on, and qualified and using government benefits. Well, if I don't designate where the money's going to go and the court decides, well, they're all going to split these assets equally, and they wind up with money, that could disqualify them for benefits.
Right. And the court doesn't care that they're on disability benefits or any other type of benefit.
Right, SSI or Medicaid or anything.
Right. They just say there's 3 kids, split it 3 ways. That's the way it goes. You guys figure it out.
Right. Right. And again, if you have minor children, family court is going to decide who's raising those kids. Which again, gets even more problematic when we're talking about a child with special needs and, really not just have anybody step in and try to raise this child at that point. So things that need to be considered, huh?
I think there's a question. Jennifer's raising her hand.
Yeah, I have a quick question. So when you do a will, say your children are adult and you're the guardian, can you appoint somebody to be the guardian upon your death? Or is that something that would have to go through the legal process?
Yeah, it's something that you have to go through the legal process.
Okay.
Yeah, you can't do it as it depends on their status. It depends on the, I won't say, hey, blanket statement there, right? Because everything is sort of specific to individuals. But generally, for the most part, if minor children, yes, an adult who's completely disabled and full guardianship. Craig, I believe that's possible, but I still think you need to go through some step there.
Well, I think what you probably do is just like everything else in the will. You want to name who would be the successor guardian in that case, and then they still have to be appointed by the court in order to do that.
Right.
However, it does go by your wishes. So like you may have a child that you think should not be, or a relative who should not be a successor guardian. And so you're specifically not naming them. So that the two don't, especially if there's assets involved, right? That can get really hairy. Let's say you're leaving a significant amount of money to the child with special needs. And one said, oh my God, they're going to inherit all this money. I want to be their guardian.
Right.
Advantage of that situation. So once again, you want the will is here to talk for you when you can't talk for yourself. And because it's not necessarily a legal contract, it's really your wishes that you want to see happen. And the court tries as much as it can to go by your wishes.
A great question. And, again, these are the state intestacy laws. That just means that you don't have a will. And that's we already described this with it. So then the next document that comes up is what's known as a general power of attorney. It's a general durable power of attorney. And the durable part just means that this is now somebody who's able to act on your behalf if you become incapacitated to do so. And so a lot of times the conversation is for even just your kids. Right. So in the situation of once your child becomes 18, they're now an adult. And you really can't interact or have conversations with any of their professionals unless you have some access to this, whether that's the medical durable power of attorney or a general power of attorney to act, in their affairs. So you really can't act on their behalf. This is more, though, when we're putting a will together and having a legal package of documents, the idea is that you name somebody, Greg, who can act on your behalf should you no longer be able to.
Yeah, absolutely. And you want to, be careful with that as well. Making sure they're going to actually do what you want should you not be able to do it yourself or be incapable of doing it yourself.
Right, because as Greg was mentioning, right, so the rules and restrictions, they vary among states, so you just gotta be careful. We mention this for people who might be living, up here in the frigid, cold Northeast, and then wanting to move south or west when they retire. Well, what is adopted here may not necessarily be the same in that state you're going to. So you just want to check that, right, Craig? That's, just good background just to say, all right, if I'm gonna, relocate to South Carolina or something, I want to make sure I know what the rules and regs are, what documents they accept or don't accept.
Yeah, the other thing you want to be cautious about whenever you're giving anybody power of attorney is, are you limiting the power of attorney? Because if you give general power of attorney, especially durable, they could sell your house. They
Right.
they could move your assets. They are basically legally you when it comes to, making financial decisions. So you just want to make sure you know what you're doing there.
Yeah, and when we talk about it being, and as Craig said, broadly drafted, a lot of times it's because what a lot of families and individuals are doing is they're gifting money out, specifically gifting money to like a special needs trust or an ABLE account or something. And if that's something that you've just been doing on your own and thinking, oh, every year I get, now it's 17,000, I can give 17,000 out. Like if you become incapacitated, that's unless it's written down or drafted someplace to say that, right? You don't, oh, what did I do there?
Something.
I don't know what I did. How did I do that? That's crazy. So that you can designate inside that power of attorney to make sure that those gifts continue, Greg, that is done as part of it.
Yeah, and what's really important too, this reminded me, is you've split gifts between an incompetent you and your competent spouse, is that your spouse, in order to act on your behalf, if you become incompetent, needs a power of attorney. Just being
Correct.
married does not give you the power of attorney. So you can't necessarily move money out of their retirement account, especially if you're living on that. If you're gonna have an account, a savings account that's not joint. So if it's not a joint asset with both your names on it, and IRAs are never joint assets, you have to have power of attorney to be able to touch and manage those funds.
Right. Right, and that brings us into the next one. It's a great lead in for that, which is healthcare proxy. And then in here, it's healthcare proxy. Other parts of the country, again, other states, it's a living will. It depends on what you get, where you are. The healthcare proxy, right, it's appointing somebody who's making those medical decisions, end of life decisions for you.
Mhm.
The HIPAA release is the ability to have conversations with medical professionals. Like Craig said, I can't have a conversation with a doctor if on my wife unless I have a HIPAA release that says I can have that conversation if she's not in the room.
Mhm.
And
Well,
go ahead, Craig.
I'll say it's especially important when you have adult children that you're caring for, even if especially if you don't have guardianship, to have that HIPAA release.
Right,
Because otherwise
absolutely.
I can't speak about their medical condition with you without their permission.
Yeah. And then a living will, again, this is the decision on end of life. In other states, they recognize living will, they don't recognize a healthcare proxy. Given you Massachusetts, it's healthcare proxy, not living will. So this is one of those, if I'm gonna go someplace else or retire and move somewhere else, I just want to know that I have all the right documents together.
Mhm.
But then when we start getting into, all right, now I've got I've got a special needs child. Now I'm going to become a special needs adult. What else should I have along with just this regular package? And the first one that we talk about is a letter of intent. We'll talk about guardianship and then, ways to go through financial security. But, the letter of intent, Craig, when we talk about the letter of intent, that's really it's more of like you said, it's not so much a wish list, but it's like a guidance, a guide for
Yeah,
them.
this is kind of like the book you wish you got when your kid was born, right? It's how to work your child, what their daily routines are, their friends, their social life. It's everything about them in case you're not there to be able to convey that information or take care of them. And this is not just if you passed away. What if you decided to go on vacation and leave them with a relative? Right. So now the relative has all the relevant information about them, including their doctors and all, the legal and financial information in case something happened to you while you were gone. So it's really just, an owner's manual per se on your kid. but something that you want to make sure is continually updated because your kids' life desires, or your financials change, or doctors change. So you want to make sure you're actually updating this on a regular basis, usually annually.
Right, and it's not a legal document, a letter of intent, but it is a consideration. So if it is submitted along with your will and your wishes and everything else that goes along with, hey, this is who I wanted to raise my child, a letter of intent is considered. So the courts will look at the letter of intent. So it's always just a good idea to have this, like Craig said, even if you're just going away for a weekend or something, or kids going away to day camp, it's a nice thing to be able to say, well, look, here's some of Joey's or Susie's concerns, type of thing.
Mhm.
So guardianship, we like this quote. It says, guardianship is the only way I can make sure that his mom or I will be able to advocate for what is necessary so he will be safe and happy. To secure this, I must prove to a court that my son is incapable of making decisions on his own. My wife and I must also choose someone to accept this responsibility when we are no longer alive and who we can trust to carry out our wishes. And that's really that last sort of impact sentence there is why we like using this quote so much, because that's really the issue, I think, Craig, for a lot of families is, okay, we know mom or dad is dealing with it, but then once mom or dad is no longer around, then what happens?
Yeah, I mean, it's really difficult for people to, when you have a kid who does not have a disability, to try to name, a guardian should you not be around. When you're dealing with a child who may outlive you, and that's as far as,
Right.
because they're going to live longer, they may outlive, other people in your family, may live to be, elderly. How are you dealing with this issue? And so, and these are tough decisions to make. And the other thing is that the responsibility, whoever you choose as a guardian, you don't want to just surprise them with that. You want them involved in that conversation, because, the responsibility they're going to be taking on, it could be a lifetime responsibility, not just until they reach age of majority.
Right, and it is a fiduciary relationship, right? You are now responsible to manage this person, their estate, their well-being, as Craig said, from then on,
Mhm.
right? So, whether we're dealing with minor child or now a legally incompetent adult, as it says on the screen, these are the things that need to be considered when we're dealing with guardianship and looking at guardianship and what's involved and what we need to be dealing with. Right. So again, once the child turns 18, they are now their own entities. And so with the next slide, we're going to talk about it, sort of a timeline when we sort of go through this, right? But the idea here is, for most families, Craig, the conversation is, should we be guardians? Should we not be guardians? When do we sort of have to have that conversation?
Yeah, I think especially when your children are really young, say under 10 years old, sometimes you're just not sure if that's going to be the case. But once they start getting into their preteens, you start getting a little better understanding of what maybe their potential is going to be, and whether or not guardianship is going to be in the cards for you. And Tom's
It's-
going to put this timeline up, which I think is let him go through, which is a great timeline.
Yeah, so no, and the reason for that is because just like that, we sort of, talk to families about having the conversation, like Craig said, from like 10 to 13, you start to get a sense and a feel, and maybe, but you can't file until you're 17 and a half. But certainly by 16 and a half, the beginning, Craig, the gathering of documents, the gathering of materials, all of that stuff should be underway.
Mhm.
Instead of waiting until 17 and a half, or worse, because once the child becomes 18, now they're an adult. Now
Mhm.
it's a different conversation. Now there's more they go to. The child can block the request. There's all sorts of things that can happen.
Yeah, we all like to think that, if this is the case, it would go smoothly and you wouldn't have any fight back from your children. But once again, if they become an adult, it's not saying you can't get it done, but there's more roadblocks and more hurdles you have to go over, and they can contest it more readily than they could have when you did it as a minor.
Right.
Doesn't mean they can't contest it when they're an adult either. They still can, but at least you have guardianship until it gets contested.
Right. And then you have 18 to 22, and then by age 26, they're on their own health care if they're not already.
Yep.
Which is how the timeline goes.
Mm-hmm.
So the last of the documents in there, right, this is where we get into trusts. And talking about trust funding, and in this case, we're talking about supplemental needs trust. Now, trust, there's all sorts of reasons for trust, right? From estate plan, we're trying to, push money aside. We're trying to do this for, legal purposes. We're trying to do this for tax planning, common uses of trust, right? Like Craig already mentioned probate. Right? So the trust avoids probate.
Mhm.
That allows you to put money aside so that any benefits that might be means tested are no longer means tested because they're assets that are now protected. They're protected from liabilities. And we can also gift to charities. So all different types of uses, all different types of trusts. They come in many different shapes and flavors and all different types of trusts there. But really what we're talking about here is a supplemental needs or otherwise known as a special needs trust. And I don't know why the screen does that.
Well, why it transitioned on you?
Yeah. It transitions out on me like that. So there's really two different types of trusts. You have a first party trust and a third party trust. We'll talk about the pooled trust thing at the end, but really a pooled trust can be either a first party or a third party. Now it's going to go again. Crazy little thing. I don't know what I did with that, Craig. I don't know why that happened. All right, so a first party trust. So first party trust is just what it sounds like. The trust is set up by the individual who is also the beneficiary. So your son or your daughter is the owner and also the beneficiary of this trust. And you would think, well, why do I want to have that happen? Well, usually, Craig, this happens for one of two reasons. One, there might have been some sort of medical or judicial award that was given, for medical malpractice or something like that, that was what happened and the child was given this money. Or it's what we call, good intentions, unforeseen consequences. Nana left some money and didn't realize should not have left it to your son or your daughter because it was going to take away their means tested government benefits. So the only way that they can do anything with this money is then to park it into a first party trust.
Mhm.
So it gets put in the trust, it's protected, not means tested, so the money just sits there. The problem with a first party trust, there's really two of them. The first one is the distributions by a trustee are very, very limited. They can only be for basic living expenses. Really can't be using the money for anything else. And then they have this Medicaid payback provision in a first party trust that says once the beneficiary, the owner, passes, then Medicaid can step in and say, well, we want to recoup benefits that we paid out from this remainder in this trust.
Mhm.
Most of the time when you're talking to attorneys, you're hearing presentations, you're going through things, you're being told about a third party trust, which again is just what it sounds like. It's somebody other than the beneficiary setting the trust up.
Mhm.
So the parents, the grandparents, family members, they're setting up the trust. The trust is to benefit the beneficiary. The money that goes in is protected. It's not going to count against any means tested government benefits. The trustee can pretty much do anything so long as it's to the benefit of the individual as far as distributions are concerned, except for housing. That's a different conversation that we get into with Abel. But they're expensive to set up. What do we say, Craig, in this area, like $5,000 or so?
5 to 7, yeah, depending on the attorney you're working with. Yep.
And in some cases, they mandate that there's money that goes in. You can't have it, what is known as a future funded trust. You got to have assets going in to do it. However, there is no payback provision. Any assets that are left, if the beneficiary passes, there can be a successor, a contingent beneficiary who then gets those funds. There's no payback provision in a third party trust. Pretty much in a third party trust, you can put just about anything, Craig, in there.
Yeah.
We're talking, real estate and stocks and bonds and anything can go into a third party trust.
Yeah, absolutely. Any asset can be held by the trust because you just own the asset now.
Right.
Mhm.
Now, we mentioned this pooled trust thing. A pooled trust is really just, it's how the assets are managed inside the account. It's not like everything's getting pooled together. Every individual has their own trust. And it can be either first party or third party, but
Mhm.
they are set up and overseen by a nonprofit organization. And the reason we mention this is, as we talked about in the beginning, a lot of times older family, older adults, parents are setting up trusts for their now adult child. And the problem is there's nobody who can be a successor trustee.
Mhm.
And they're getting to the point where either they're passing Craig or they're becoming incapacitated. And then they're left with, well, who's going to oversee this trust?
Yeah, I mean, I like pool trusts for that reason, just for the fact of the continuity, because it is a company, it's not an individual. Like sometimes you'll see an attorney will say, well, yeah, well, I'm happy to act as a trustee on the account, but unless it's a firm with continuing partners, and what if that attorney passes away? You know, you're still in the same situation. So I like the continuity. I also like the fact that pool trusts kind of specialize in dealing with these supplemental needs trusts. And so they know all the laws and rules and they keep abreast of them as they change. So it's almost having a counselor with a checkbook, right? They really know all the ins and outs and exactly how to operate in this environment.
But they also have drawbacks as well.
Mhm.
One, they can't hold all the assets like a third-party trust normally could.
Can't put a
You've
house.
got, yeah, no, it's pretty much got to be cash usually. That's the whole pooled investment thing that goes on.
Mhm.
And then they have the same Medicaid payback provision, even if you're in a third-party trust, that a first-party trust does.
Mhm.
Where in a pool trust, Medicaid could step in. It doesn't happen all the time, but they can step in and say, wait, we want to get paid back for benefits that were paid out should there be remainder assets in the trust. So just be aware that there are some limitations there in terms of pooled trusts.
One other positive though is it's cheap to set up. It's like $500 versus $5,000.
Oh, yeah, yeah. It's a low cost and you can future fund. By that, I mean, you can set it up and just say, you know what, well, whatever's left over, we'll just sell it and move it into the trust.
Yep.
So how do you fund a trust? Right? That's one of the questions that comes up all the time. Like, well, okay, I set the trust up, but now what do I do? How do I fund this thing?
Fund mine with
And
scratch tickets, then you'll never know what it's going to be. It's a big surprise.
yes, it's just a surprise.
It's a scratching.
So we talk about looking at the assets, right? And this is what happens for most people because we really most people have two major accounts, right? I've got my retirement account and I have my home. So a retirement account has gotten better thanks to Secure Act 2.0, whereas before it wasn't, because now you can stretch the distributions out in a retirement account. By that I mean someone who is differently abled. Secure Act 2.0 says an IRA beneficiary there can stretch the payments out for their lifetime instead
Mhm.
of being in a 5 or 10 year window.
Mhm.
So that's a good thing, but you still end up having to pay taxes on it. You still have to determine if you're going to do it. You need one that's going to be able to make the distribution, Craig, and hold the money. So you don't have to distribute like a required minimum distribution.
Yeah, absolutely. And like I said, that's some of the drawbacks for retirement assets is they're great for retirement, not necessarily fantastic for estate planning because of all the tax implications that are involved with them.
Right, and the rules, and you've got required minimum distributions that have to come out. Now, like I said, you can set the trust up so that it can distribute the required minimum distribution and then still hold it.
Mhm.
But you're still getting into the whole conversation of tax and tax efficiency and how that all works.
And if you're talking about retirement assets, Roth assets are typically a little more favorable than using, pre-tax dollars.
Right, right, because you don't have the required minimum distribution and you don't have a tax consequence.
Correct.
So real estate, a lot of times we have this, families will come, and they'll say, well, I just want to leave, they're living in the house. I want them to be able to stay in the house. I want to just, gift the house, put the house in the special needs trust for them,
Hmm.
which is fine. But then we have to go through, well, is there a mortgage on the house? What about taxes and upkeep to the house, insurance on the house? And unfortunately, what happens in that situation is you wind up with a trust that is house rich and cash poor. And
Mhm.
at some point out into the future, that real estate has to be sold because you can't take a mortgage on it at that point.
Right.
So something has to be done with it because, Craig and I joke all the time, like you just can't take a door off and walk down to the bank and go, hey, look, can you give me a couple $1,000s? It doesn't work that way. So while real estate is a very nice and good idea, unless there's additional funds that are available that can be also parked into the trust, a lot of times it winds up in a situation that not too far down the road, the house has to be sold anyway. And then you wind up in a situation that becomes much more complicated than really wants to be dealt with.
Right, because someone's got to step through that process. Even if you have the cash in there, someone's got to maintain the property, pay the taxes, do all that upkeep, and you generally, just like keeping your own home. You're a
Right.
landlord at that point, right?
And then the same with securities, they're kind of like the retirement plan. It's securities are fine. They're actually very good in there. But then essentially, eventually it comes to well, who's making the decision of when to sell and what to sell?
Mm.
And who's responsible for that? And we talk about this with people who are in retirement all the time. Like it's one thing to say, oh yeah, no, I've got the security and it's there. But what if I'm drawing off that because now I need to be living on it, and at the same time it's fluctuating in value? Well, if the market drops and I'm taking money out, it's going to be hard for me to recover. And how am I dealing with that? And who's watching it? And how are they watching it? So while securities, again, it's okay to do it into a third party trust, not necessarily the best, most efficient way, Craig.
Yeah, the other issue you got to consider is if you do have a gain in your security and you take it out, what's the tax rate going to be? Because trust rates aren't as favorable as personal income.
Correct. Or capital gains.
Correct.
So whenever we talk to families about this, one of the things that we always say is, look, if you're going to get a special needs trust, one of the most efficient ways to fund a supplemental needs trust is by using life insurance. Because life insurance is something that you can say, I'm going to pay for this amount now, leverage the dollars, and I know at some point out in the future, when I am no longer here, that amount of money is going to go into the trust for my child's future benefit. And Craig, it looks a little something like this. Not too deep in terms of it, but if you just want to walk through that.
Mm-hmm. Oh, you want me to walk through it? Sure.
Yes, please.
So one way to set this up so it keeps it out of your estate, and we're talking a little bit about estate taxes and those types of issues, but to keep it out of your estate, the trust owns a life insurance policy on you. And what you do is you give annual gifts to the trust so that they can pay the premiums on that policy. Okay, you being the grantor of the policy. At your death, the life insurance proceeds go into the trust because the trust is now the beneficiary of that policy, and then distributes the assets for the care of your child. So what it does is it keeps the entire thing out of your estate, so it's not subject to any estate taxes. Everything passes tax-free into the trust, and then all that money is now available to care for your child should you pass away.
And all of it is away from any of the means tested government benefits that they are qualified and entitled to receive.
Right, because the child never owns it. The trust owns it.
Correct.
Mm-hmm.
So it's the most efficient way to do this. We talk about it all the time because the other is I can then say, I've now set aside this amount of money. In this case, Mike is the loved one, for Mike's care for the rest of his life. I don't have to worry about my other stuff. I can spend that because that's what I need it for. And we'll talk about that in a little bit. But see, as we talked about with the will, not everything passes by wills. And so you have all of these conversations, these life policies and IRAs or retirement accounts, other, employee benefits, annuities, savings bonds, all of these things have beneficiaries on them. And unless you go back in and do this on a regular basis, and we talk, Greg, usually like every 3 to 5 years with beneficiaries.
Yeah, because life changes, and sometimes we'll set something up. I mean, I've seen people that they get married, and before they got married, they had an IRA, or a 401k at work, and their parent was the beneficiary. Well, 30 years later, they never updated it, and their mother is still the beneficiary on their policy, even though they've been married for 30 years. Or Tom and I practically had some cases where the beneficiary died. They predeceased the person who was on, had the account. So now you've got no beneficiary. And so now you're trying to name a beneficiary after death, and that, through means of the will, and that becomes more difficult. So it just makes sense to review these on a regular basis. Just make sure.
Right, it's very, very important to do, and it's the same thing with family. We talked about this good intention, unforeseen consequences, because sometimes like family members may not know. They may just be thinking like, oh, okay, I've got, with the grandparent, I've got 6 grandkids. I'm going to leave them all each an equal piece, not knowing that little Mike should not receive that little piece because it's going to trigger and disqualify him from his benefits that he's receiving. So, Craig, one of the things is communication is very, very vital here.
Yeah, and like I said, sometimes this is tough. I mean, sometimes families keep things close to the vest. They don't want them to know all the information about their health or their child's health. But once again, when it comes to the financial concerns later on, these could be things that can really trip you up and not meaning to. Like I said, best of intentions, but you have dire consequences. You get knocked off benefits. So
Right.
communication is key when you're dealing with these types of situations, just so you can manage that piece.
Yeah, and one of the things that we talked about a little bit there with the whole planning thing, right? So what makes planning hard for most families in this situation is not only, hey, I'm trying to plan for my future, retirement, which was hard enough for everybody, but now I'm also trying to plan for little Mike, because what happens when I'm not around, he needs to be taken care of as well. And that's sort of what we were saying with the whole going back to the life insurance thing, whereas with a life insurance contract going to a special needs trust, I can actually designate that's the money that's going to take care of Mike. Now, all my other stuff, my retirement account, the home, whatever else I got, now that can take care of me. And see, the problem for most families, Craig, is that they run into well, I'm using all of the same bucket to try to do both things.
Oh yeah, I see a lot of people say I'm just going to leave remainder assets. I have a lot of money in my 401k, and whatever I don't use in retirement can go into that trust. What happens is either you slow down your retirement spending because you want to make sure you put money away, so maybe you don't enjoy retirement the way you want to, or something comes up like a medical necessity that depletes the funds and they're not available anyway, right? So the way to take the pressure off of that is to have that plan set up for little Mikey, so that now the rest of the assets, they're yours. And now you could plan like you would have, because you've already put that piece away and you've got that peace of mind that that's taken care of.
Right, that is all set. And and the other thing with any time we're doing any type of long-term estate planning type of thing, is just know, as Craig said, things change, stuff happens. This is not a, hey, I'm gonna just have this and gonna do it this weekend and I'm done. It's an ongoing thing because stuff zigs and zags. We know life happens, right? So it's one of those sort of, just like doing everything else, coming back every couple of years and saying, okay, are we still on track? Are we still in processing the way? Are all the beneficiaries up to date? Are the people who are going to be the successor trustees or the next generation going still in place to do that? All of this stuff needs to be sort of gone through as a checklist to say every couple of years, all right, we did it, we're okay. So just know it's one of those things that for everybody, and again, this is typical as well as in special needs community, everybody's got to be doing this on an ongoing basis. So one of the things we offer to all families is an opportunity to have a conversation with us. That QR code right there on the screen, I don't know why it says 7 Hills, but that's okay. But that's for tonight's audience. I don't know what I did there. Must have borrowed this slide off of a different presentation. But the link is active. The QR code is active. Craig, do you have the link to share in the chat box?
I am looking real quick. I think I might, but just let me take a look. Yep, I have the webinar link.
Okay. So
and I'll put in the yes, and I have the calendar link as well.
Okay, so the calendar link, thank you very much. So Craig's dropping it in the chat box. You just click on that, that'll open our calendar, and you can just schedule a time with us, or just open your phone and shoot the QR code. It'll open up our calendar. Because we know sometimes a lot of these conversations are deeper and more involved, and so it makes it easier to have that one-on-one conversation. And just so you know, there's no cost, there's no obligation for any of this. We do this just trying to, again, give back and help into the community. Did you drop this one in there? Did you say that?
I was just waiting for you to tell me to. It's in there
Oh,
now.
there we go. So if you can drop, so one of the favor we ask for everybody is if you could just take a moment and go through and just answer. It's take you 2 minutes online. It's just an evaluation form. We do these for a lot of organizations, just like Crossroads. We do them for community support groups, and we do them for the state of Massachusetts. So we like to get feedback. I will tell you, there is a yes or no button on there. Just be aware that if you say no, you're never going to hear from us. It's a promise we make to Crossroads. It's a promise we make to every attendee at any one of our presentations. But if you want to meet, that's another way you can do it. Just say yes, and we'll reach out to you and schedule a time that works for you. And on that note, that was pretty much everything that we had. Feel free if you want to. I'm going to stop the recording. So if you feel free.